Indian legal system is largely based on English common law system, where the law is made by parliamentary process and jurisprudence over it developed by judges through their decisions, orders and judgments. The supreme law of India is Constitution of India. The nature of Indian Constitution is quasi-federal, which means there is a dual system of governance in India. That is the union government and the state government. The powers between the union government and the state government are determined on the basis of union list, on which union, that is the central government, can make a law, the state list, where only state government can pass legislation, and the concurrent list, where both state and central government can both make law. Indian democracy is based on following pillars. The first pillar, the legislative branch, that is the Parliament of India, the lower house and the upper house, or the legislative assembly of state, having authority given by the constitution to make or repeal the laws. The second pillar, the executive, having the power to execute those laws and implement policy formulated by legislatures. The third pillar, the judicial branch, which interprets the constitution, law of the legislature, or rules made by the executive. It ensures a sense of justice and fair play prevails in society. All three pillars are independent but at the same time interlinked with each other to ensure smooth working of democracy. How laws are made in India? Lawmaking is a very complex process in India. In India, at the central level, laws are formulated by Parliament, and at the state level by the legislative assemblies and councils. As a first step, the government or citizen group in India identify the need for a law or amendment of any existing law. The suggestions for such law is collected and forwarded to concerned ministry in India. As a second step, the concerned ministry examines the suggestions and comes up with a draft law in form of a bill, which is circulated for discussions and public comments. After considering the inputs, the final bill is sent to the cabinet for approval. As a third step, the cabinet headed by the Prime Minister of India discusses the bill and approves the same to be introduced in the Parliament of India for discussion. As a fourth step, the bill is introduced in the lower house, that is the Lok Sabha, for discussion. And after it passes the same, it is introduced in upper house for discussion, that is the Rajya Sabha. And as a last step, after both houses of parliament pass the bill, it is presented to the president for assent, and after the president assent, the bill is notified as an act. Further, the bill is brought into force and rules and regulations to implement the act are formulated. What is the judicial system in India? The Supreme Court, also known as Apex Court in India, is the top court and the last appellate court in India. And the Chief Justice of India is its top authority. High courts are the top judicial bodies in the states, controlled and managed by Chief Justices of those high courts. Below the high courts are district courts, also known as subordinate courts, controlled and managed by district and session judges. There are also specific quasi-judicial courts known as tribunals for specific laws such as income tax, goods and service tax, customs, company law and security laws. The Indian judicial system is totally managed and administered by officers of Indian Judicial Service. The expression judicial service means a service consisting exclusively of persons intended to fill the post of district judge and other civil judicial posts inferior to the post of district judge. The judges of subordinate judiciary is appointed by Governor of State on recommendation of the High Court of the state. The judges of High Courts and Supreme Court are appointed by President of India on the recommendation of Collegium of Judges. The judges for economic law tribunals are either lawyers or chartered accountants. The cases are argued by advocates licensed by the Bar Council of India. For economic laws such as income tax, goods and service tax, customs, company law, and security laws, the cases can also be argued by chartered accountants in India. Legal framework is of the utmost importance while doing due diligence of the area where an investor seeks to establish its business. Similarly, for setting up a business in India, it is important to understand the applicability of fiscal and economic regulations in India. Some of the important fiscal and economic laws are: firstly, entity-related laws, such as the Companies Act, which regulates the formation and functioning of companies, the LLP Act, which regulates the formation and functioning of limited liability partnerships. There are business laws, such as the Foreign Exchange Management Act, which regulates the current and capital account transactions which are incurred while dealing foreign currency. The Insolvency and Bankruptcy Code, which specifies the procedures and regulations which are required to be complied while winding up or closing the business entity in India. The Competition Act, which prohibits anti-competitive agreements or abuse of dominant position. There are tax laws, such as Income Tax Act, which regulates the direct taxation in India, Goods and Service Tax Act, which regulates the indirect taxation in India, Customs, which regulates import or export and its related procedures. India has a plethora of labor laws, which are now being consolidated into 4 codes. That is, the Social Security Code, the Wage Code, Occupational Safety, Health and Working Conditions Code, and the Industrial Relations Code. Other important labor laws are Shop and Establishment Act, Sexual Harassment at Workplace Act, Child Labor Prohibition Act. There are also state-specific and industry-specific labor laws. There's Information Technology and Privacy laws in India. Information Technology Act is the primary law in India dealing with cybercrime and transactions carried out by the means of electronic data interchange and other means of electronic communication. India is also in the process of introducing much awaited Personal Data Protection Bill, which seeks to protect the privacy of personal data in India.